trial and the jury says you're not guilty, they can't say, okay, well, let's do this again. What can get confusing is you might find yourself in a court of law multiple times for the same action. You can, in one action, be breaking a law and also doing wrong to another person and find yourself in criminal and then civil court with regards to that matter. The most famous part of the Fifth Amendment is your right to not testify against yourself, to plead the Fifth. That is so that you cannot perjure yourself, but also not incriminate yourself. And the two most important clauses of the Fifth Amendment that we come back to really have to do with property. The Fifth Amendment says you cannot be deprived of life, liberty, or property without due process of law. Can you be deprived of life? Can the government take your life? Absolutely. Can the government take your liberty? Absolutely. We have a large prison population, and we absolutely do have capital punishment. Can the government take your property? Absolutely. In all three of those cases, as long as the government's following the rules, which is what due process is, then the government can take all three of those things, and those words made famous by John Locke. And the government takes your property usually through fines. So if you've had a traffic violation and you've paid your ticket, when you paid your ticket you said, I am guilty, here's some property, and you move on with your life. And then the last part of the Fifth Amendment, kind of most disconnected from the other ones, has to do with private property, again, being taken by the government. And it says that the government can take private property, but it has to meet two requirements. It has to, one, be used for public, and two, it has to be used, or you have to be given just compensation, that you should be financially compensated. And generally that compensation will be the fair market value, which the court has defined as what a willing buyer would pay to a willing seller. And most common you'll hear today on the news and things in Austin, especially with UT, eminent domain. That is the term to describe when the state takes someone's private property to use it for public use. In this country, eminent domain was most widely used with the expansion of railroads. Okay, read the sixth and then we'll debrief. Okay, the Sixth Amendment. This one is about criminal procedures, so criminal cases. And essentially, it's focused on making sure you have a fair trial. What makes the trial fair? It's speedy. That doesn't mean that it's hastily done. What that means is that your trial is not delayed. So instead of you being charged with a small crime and being told, okay, you're going to have a trial, but that's going to be in 6 years, just wait here in jail, that'd be like punishing you before you've had your trial. So it needs to be done rather quickly. It also needs to be public. You want your jury to be of your peers and impartial without too much bias. Jury selection is supposed to get an impartial jury. And in jury selection, what will happen is a number of people will be brought in. If you ever get jury duty, you'll be there with many more than 12 people. You'll start off with anywhere from 40 to 100 people. And here the prosecution and the defense attorneys get to sort of interview potential jurors. And they each take a turn kicking someone off until they have 12. Another part of a fair trial, to make sure that your jury is of your peers, the trial happens where the crime was committed. And that's why we have district courts throughout the country. So that way when you are charged with a federal crime, you don't have to go to D.C. for your trial. And keeping up with the adversary system, both sides essentially get to do the same things. They both get to call witnesses. They both get to present evidence. They both have opening and closing statements. And to make sure you have a fair trial, you are supposed to be given counsel. Now this is tricky, and the Gideon v. Wainwright case clarifies it, but originally the Bill of Rights is to limit the federal government. It applies to the federal government. So what if you're in a state court? Could the state court say, oh, you don't have money for an attorney, too bad? That was the case up until Gideon v. Wainwright. And then with Gideon v. Wainwright, that incorporates the Sixth. It says this part actually does apply to state governments as well. All right, pause this for the seventh, read the seventh, and then we'll debrief. Okay, so the seventh follows the sixth. There's kind of logic here. The sixth was about criminal cases. The seventh is about civil cases. And this ensures that you have a right to a jury trial in suits above $20. That is still the current rate. And this, too, is about property. But generally when we're talking about our concern about property, the concern has been, oh, the government will take your property in some way, and you don't want the government to do that. But what if someone else harms you or your property? Do you have a way to get that property back? The government provides a court system for you to settle those disputes. So the Seventh Amendment pertains to settling those disputes. Particularly, there's an emphasis on the property there to make sure that others don't harm your property. All right, read the 8th. And, all right, so what's bail? Bail is the money that you pay in order to go home for the day or the week. Okay, bail is not the end of the deal. Bail is essentially collateral. It's what you put up, and it should be a really high number for you. It should be something that you probably have to go borrow. And you give it to the court, and you say, I will come back. Okay, I'm not saying I'm guilty. I'm going to come back to my trial. And when you come back, you'll get that money back. So bail allows you to not sit in jail while waiting for your trial. It allows you to go home, sleep in your bed, kiss your kids goodnight, get ready for your court date, and then show up to court and you get your bail back. So what makes bail excessive? What's going to make it excessive is actually your flight risk and your wealth. So the wealthier you are and the fewer connections you might have to your local community, you might be a flight risk and have the ability to flee. So there are some people who might be so wealthy that they'd pay bail and just say, nah, I don't need that money back. So we got to make sure bail's high enough relative to their wealth, income, and flight risk. Fines, that's what you pay when you're guilty. And you often forego your trial. Like when you have a traffic violation, you go, okay, you caught me, I was going 10 miles over the speed limit, here's the fine. When you do that, that is an admission of guilt, and it's a way for you to just move on. So what makes the fine excessive is not necessarily, it's just not relative to your earning power or your wealth. What makes the fine excessive is it proportional to the crime? So the bigger the crime, the bigger the fine. The smaller the crime, the smaller the fine. And then finally, no cruel or unusual punishments. This is usually where people who oppose the death penalty will go to in the Constitution. They would argue that the death penalty is cruel or unusual. So what you should be noticing is in all of these thus far, there's an awful lot of property rights embedded in the amendments. Locke would be so proud. Obvious ones first. The Fifth Amendment mentions property twice, the Due Process Clause and the Just Compensation Clause. So that should be the most obvious. Then you have the Eighth Amendment, which talks about bail and fines. So both of those are times that the government takes your money, which is your property, your wealth. So we've said Fifth, Eighth. The Seventh protects your property from others, that you have civil suits as a way to get back damages. The Fourth Amendment, the Searches and Warrants Amendment, also has the idea of property in your house, your things yourself. And the Third Amendment, also because it's about your home, has those ideas of property. Most recently added to the list of property rights in the Bill of Rights would be the First Amendment and its relation to intellectual property, that your ideas are yours. Okay, so Locke would be very proud. Let's look at the last two. The last two, the 9th and 10th. Will you read them both together? You might have clarity by reading them both together. So pause this, read them. Okay, so what you should see here is the 9th and 10th don't really list anything specific. There's no meat, there's no takeaway. So the 9th and the 10th really are there, I would say, for the Federalists. The Anti-Federalists wanted to limit the government to protect your liberties, but one of the arguments against a Bill of Rights from the Federalists was that by having a list of rights, you're going to somehow limit rights, because if you have the list, here's everything you can and can't do, then whatever's not on it will not be answered, so to speak. So the 9th and the 10th sort of address that issue. The 9th is often called the rights retained by the people. It doesn't give you an actual right, but it addresses the problem of the list somehow limiting your rights. So another way to think of this is the 9th Amendment is saying, hey, just because it's not on the list doesn't mean it's not a right. And this is maybe really what makes the Constitution, what the framers were thinking, so effective, is they knew at the time that they weren't going to be able to answer every single question, and this document would need to be able to wiggle and adapt and change, and the Ninth Amendment leaves that open. So if the Constitution doesn't specifically recognize a right, that doesn't mean that it doesn't recognize the right. But it does leave us the questions of, well, then what are those rights? And generally it's the courts that answer that for us, more than the other two branches. The 10th Amendment, very similar again, in that it doesn't give a specific power, but it has to do with states' powers. So remember, this is the reserve powers, or the States' Rights Amendment. And this is saying, hey, if it's not specifically given as a power to the national government, which would be Article 1, Section 8, the enumerated powers, nor prohibited to it by the states, that would be Article 1, Section 10. If it's not on either of those lists, Article 1, Section 8 or Article 1, Section 10, then that's left to the states. And this is allowed for things like Jim Crow laws. So we got the 9th and the 10th Amendment is both sort of ending the Bill of Rights, saying, hey, if we haven't gotten to something, it's either left to the people or to the states. Okay, so now that we have actually looked through all the amendments and seen what they are, my question to you, do you have a right to privacy? So pause this, look through the Bill of Rights. Do you? Okay. So the right to privacy, the word privacy is not written there at all. But you might have looked in the Bill of Rights and said, you know, there's an idea of privacy. The idea of privacy you might have found in the Third Amendment, that protects you from quartering, and that really protects random men from coming and staying in your home and eating your food and being in your space. You also might have said, hey, the Fourth Amendment requiring officers to have warrants to search you also has the idea of privacy. But it's not clearly there, so we have to pull in the 9th Amendment to make that work. This is similar to how we pull in the elastic clause to create an implied power. So this has been articulated by the majority opinion in the case Griswold v. Connecticut. In that case, the Supreme Court, the majority opinion, explained that by way of the Third, the Fourth, and the 9th Amendment, there is an idea of privacy. And this is the case that has to do with access to information about contraception in the state of Connecticut. In the state of Connecticut, the doctors were prohibited from giving contraception information to their patients, even to married couples, as was the case here, and a doctor could be fined or imprisoned for doing so. The Supreme Court ended up ruling on this, striking down Connecticut and other states' laws that might ban doctors from giving that kind of information. But really the heart of the opinion has to go with, do individuals have a right to privacy? And in this case, the court said, especially in marriage, you have a right to privacy. This case really lays the groundwork for Roe v. Wade, which would come shortly thereafter. Okay, our final topic now to get us ready for the next topic of incorporation is about this Bill of Rights. The compromise between the Federalists and the Anti-Federalists was a compromise to limit the federal government in order to protect people's liberties. But it's a pretty good list. It's a pretty good list of liberties. So the question is, do the states have to follow these rules? In 1833, in Barron v. Baltimore, this was the Marshall Court, the Supreme Court actually clarified that the Bill of Rights only restrains the federal government. This is significant because it signals to states that they don't necessarily have to follow this set of rules. So different from other decisions from the Marshall Court. We saw with the Marshall Court an expansion of the federal government by way of the Gibbons case expanding the Interstate Commerce Clause, or the McCulloch case asserting national supremacy and the implied powers doctrine. In this case, this is a big win for the states. So that's where we're leaving off before we get to incorporation.